सेकंड क्लास करने वाले हैं. Am I audible?
Yes, ma'am.
Okay. आपने फर्स्ट क्लास का रिवीजन किया या फिर डायरेक्ट गो थ्रू किया आपने? साथ साथ में करते जाइए. That would be helpful. Just give me. Okay, Ananya, that's great. You are doing it. Just give me 1 minute. I'll share the screen. Okay. So today we will start with conditions and warranties. The first section 11, it talks about stipulation as to time. So the word stipulation, anybody has idea what do you mean by stipulation? स्टिपुलेशन क्या होता है?
Ma'am, binding someone with certain condition.
What? Can you repeat it?
Ma'am, binding someone with some condition.
Binding someone with some condition. Okay. Anybody else? स्टिपुलेशन का मतलब ये हुआ कि आप कोई रिप्रेजेंटेशन या कोई स्टेटमेंट दे रहे हैं. Ananya is saying specify or demand some amount of time in this case. No, we are not discussing about this entire particular. We will go into the entire reading. First, we are trying to understand what do you mean by stipulation. So, because it might be as to time, it might be with regard to anything else also, right? So, what exactly the stipulation itself means? So, stipulation itself means any kind of statement or representation which has been made by either buyer or the seller. Okay. And now this statement or representation has been made for what? That we will see in our next in further sections. So general meaning as in general layman meaning stipulation का मतलब हुआ कि आपने कोई statement या representation दिया है and वो किस लिए दिया है और उसका क्या purpose fulfill होगा वो depend करता है. If suppose in case here in this section what it exactly saying that stipulation as to time. So this that means the buyer would have given certain representation or certain statement with regard to time, right? So what the section is saying, unless a different intention appears from the terms of the contract, stipulation as to time of payment are not deemed to be the essence of contract of sale. अगर आपका इंटेंशन नहीं है बायर का time as an time is an essence, then in that case what stipulation as to time is that essential that is a representation or any kind of no essence for that contract. If the buyer is not saying that as to time maybe with regard to delivery, as to time with regard to payment, here it is saying as to time of payment. So the time of payment must be with regard to seller, right? So if the seller is not specifying as that time of payment is not an essence of a contract, then it is not. in general parlance. But if the contract, the terms of contract, it is saying that time of payment is an essence, then it will consider as an essence, otherwise not. Okay, whether any other stipulation as to time is of essence of the contract or not depends upon the terms of the contract. So time may be with regard to your delivery, or delivery is usually buyers delivery is usually the essence of a contract, unless and otherwise it has been stated something else. But however, with regard to time for payment, unless different intention is not is there, unless the seller has not specified that time for payment is an essence, time for payment of price is not deemed to be the essence of a contract of sale. This is what the section is trying to say. Okay, what do you mean by the essence of a contract? Or if you can say that time is of essence of the contract. Okay, uh, so what do you mean by time of an essence? We have discussed about payment, we have discussed about delivery. Is there any other way around wherein the time is of an essence? Suppose the goods is of perishable nature, that time itself also the no, buyer would have mentioned that since this is perishable nature, so it should be delivered within 2 days. So obviously it is with regard to delivery, but it has to be kept no with according to certain uh, suppose the freezing degree should be specified, or certain other criteria should be specified. So there that for with regard to, like, suppose 7 hour, it has to be kept in certain scenario, so it has to be kept in certain scenario. So there also time is the essence of the contract. So if you have not kept certain goods for certain time period in certain scenarios, like certain criteria has been prescribed, then if that has not been done, then also it is violating the terms of contract, right? And the contract can be avoided, and that we have already read it, that if suppose time is the essence of the contract is provided by the buyer, but if the seller has not fulfilled those criteria, then in that case the buyer has option either to avoid the contract or either continue with that contract. Section 12, condition and warranty. Okay, so in section 11 we have discussed about stipulation as to time, but stipulation maybe, or maybe for any other reasons, like it might be that the seller might be saying that ki, this good is the seller might be representing that this good is so wonderful that it will last more than your lifetime. Like you have might have seen the Fevicol ad, wherein it has no it what the seller is giving one kind of representation कि ये टूटेगा नहीं, right? So that representation is also a stipulation, and with regard to by seeing that representation, the people are buying that good. So a statement or representation made to induce the intending buyer to purchase the good is your stipulation. Okay, can the stipulation be made by both the parties? See, if the seller is making such stipulation, then it form part of a contract, because the buyer has relied upon them, and they are so relevant that if that representation has not been made, buyer would have not purchased that good, right? So it has legal effects on the contract of sale. If that representation which provided by the seller is not true, then buyer can repudiate that contract, right? But because buyer has bought that good only because of that representation. The uh, uh, similarly the buyer can also give certain representation or certain statement that he want certain good which has this criteria. Suppose you went to a car showroom and you said that ki you want a car which fulfill which is for touring purpose. So, you want such a car that it has certain number of seats and it is suitable for the purpose of traveling. You have the travel agency and it should be suitable for that purpose. In that what you have also made one statement. So this is also a stipulation, and if that stipulation is violated by this seller and he has provided you a nano car, that will obviously not suitable for you for the travel agency purpose, right? And the buyer can repudiate the contract. So from this understanding, what we are trying to understand is that when certain representation which is forming part of the contract of sale and affect the contract is your stipulation, and if such stipulation is very significant or essential to the main purpose of contract, then it is a condition. Like your like when the buyer has mentioned that he want a car for travel agency purposes, so it is essential to main purpose of contract, right? If that car is not serving that purpose, then buyer would have not bought itself. But certain no certain representation might not be so significant, like your horn should function well, right? This is a very less significance or collateral to the main purpose of contract. So you might will tell to the seller that okay, I want a car which should be suitable for the purpose of touring purpose, travel agency. But you might also tell that the horn should have no particular sound, or it has loud noise, or something like that. So it might be not so essential to for the purpose of purchase. So it is collateral to the main purpose of contract. So what is very essential, that is your condition, but what is collateral to the main purpose of contract, that is your warranty. Okay, so now we'll read the section what it says. A stipulation in a contract of sale with reference to goods which are subject thereof may be a condition or a warranty. Just we have understood that any representation or statement might be your condition or a warranty, right? Like your a car which is suitable for travel agency, that is your that stipulation is your condition. But horn has particular sound, or horn should be having no scratch proof or something like that, that is your that stipulation is your warranty. Now, second point, a condition is a stipulation essential to the main purpose of contract, the breach of which gives rise to a right to treat the contract as repudiated. Okay, why it is not mentioned as revoked or terminated? Because the contract has been made. So before before the conclusion of contract, revocation is possible. After the conclusion of contract, only repudiation or rescission is possible. Okay. So if that main purpose of the contract, if that is stipulation, uh, if that is breached by the seller, which is essential to the main purpose of contract, then buyer has right to repudiate that contract. But if it is collateral to the main purpose of contract, like your horn should be scratch proof, should not have scratch, that is not so significant. In that case, if it is breached by the seller, then the buyer can claim for damages but not have a right to reject the goods and treat the contract as repudiated. Okay, so in case of breach of warranty, buyer can only claim damages, but it cannot reject the no good, or cannot treat the contract as repudiated. Fourth point, whether a stipulation in a contract of sale is a condition or a warranty depends in each case on the construction of the contract. A stipulation may be a condition, though called a warranty in the contract. Can anybody think of it? Any suitable example which can justify this? What this section is saying that ki sometime what happened, which might seem as condition, you may in the term mention it as a warranty, right? So it depends upon how you are framing the contract. Can anybody think of example? Which prima facie looks like it is a very main essential purpose of the contract, but you might treat as a warranty in the contract, like you, that might not be relevant for you. So it completely depend upon buyer to buyer. Section 13, when condition to be treated as warranty. Okay. Where a contract of sale is subject to any condition to be fulfilled by the seller, the buyer may waive the condition or elect to treat the breach of the condition as a breach of warranty and not as a ground for treating the contract as repudiated. Do you think it is as a voluntary? No, you are treating it as voluntary as a warranty, not as compulsory, because you yourself is waiving it. So if you are saying that okay, something is a condition, you have also mentioned in the contract that and the stipulation you have yourself given it as the main essential purpose, essential part of the contract. Like suppose the car owner, the showroom has given you a nano car. So in that case, you would have no, you have an option, either you repudiate the contract and you will not accept that nano car. But if you waive that condition, you think that okay, I instead of using it for my travel agency business, I will give it to my son. So you are waiving that condition, right? You are still accepting that good. So it is a voluntarily treatment wherein you are treating the condition as warranty. So where a and you can claim damage. Second is, or elect to treat the breach of the condition as a breach of warranty and not as a ground for treating the contract as repudiated. The same thing, you can either just treat it as a warranty and will not even no you accept the good, you don't, you will not no cancel, you are not repudiating that contract, or you might treat as a warranty and you can ask for the damages. Second point, where a contract of sale is not severable and the buyer has accepted the goods or part thereof, the breach of any condition to be fulfilled by the seller can only be treated as a breach of warranty and not as a ground for rejecting the goods and treating the contract as repudiated, unless there is a term of the contract express or implied to that effect. Okay, here there is two things saying. Okay, one, it is saying that contract of sale is not severable. So it means that there is a representation which is even a condition as well as a warranty. That can be possible, right? So you are not able to separate the condition out, condition and the warranty. uh, a representation which has been made is such that it is even a representation as well, even a condition as well as a warranty. If I give you an example, suppose that you have bought a furniture which is made of certain xyz good, and the seller has mentioned that this is of xyz good. With that representation you have bought that furniture, and also the seller has mentioned that this xyz good lasts for 5 years. Okay, now this is your warranty. So the same thing, that xyz good has both condition as well as warranty. So if it is not xyz good, say I can say that if it is a teak good or any, no, any other good, any other wood. So if it is not that quality which the seller is saying, that time he is not only breaching the condition but he is also breaching the warranty. Correct? Secondly, if the buyer has accepted the goods or part thereof, Here in this case, if I say that, suppose if I give you an example, suppose a seller has mentioned that a particular rice is of XYZ quality of basmati rice, and now, no, after you took that rice, you went to your home and you cooked that. In that, you found that some other quality has been mixed. Now it is not separable, right? And simultaneously, you have also consumed the part of it. In this case, when you have already accepted the good, entire good, either you have accepted the entire good, or if you have consumed the part thereof, then in that case, the breach of any condition to be fulfilled can only be treated as a breach of warranty and not as a ground for rejecting the goods. I hope it is clear, because it is little confusing. If you have certain no, queries in this, please free to ask. This is only confusing point. Otherwise, condition of warranty is very simple. Okay. From this, I think most of you would have understand what is condition and what is warranty. Can anybody able to say me the difference? Last point is pending, I think, third point. So nothing in this section shall affect the case of any condition of warranty, fulfillment of which is excused by law by reason of impossibility or otherwise. So suppose if this seems as a compulsory conversion, wherein the condition is converted as warranty because the law has excused it. Okay. So some if the law is itself saying that say if I say that in a particular state, say in Gujarat, the alcohol is banned, but before banning the alcohol, it was allowed to be traded, right? So if you have not no served the people whom, if the buyer has requested, if the buyer has ordered to serve alcohol in the party, and the seller has not served it, and instead that he has served some other kind of drink, no alcohol free drink, in that case he has not breached the condition because the law has excused him. Okay, so this is a compulsory conversion, or by reason of impossibility or otherwise. So any other like suppose because of any kind of war, that kind of that no there is some destruction, and because of that the delivery is not possible. So in that case also it is impossible, right? It is impossible to fulfill that. So in the first two condition we have seen, it is a voluntary conversion, and the last point is your compulsory conversion. Now, we have already understood what is condition and what is warranty. Could you able to differentiate between condition and warranty? Anybody? Yes, Ananya. In condition, the stipulation is essential to the main purpose, but in warranty, stipulation is collateral. Very, very correct. Okay. And the next point, in breach of condition, contract can be repudiated and damages can be claimed. Okay. In this, Ananya, there is one thing. In breach of condition, contract can be repudiated, and either the buyer can repudiate it, or buyer can claim damages, or buyer can do both. Okay. It is not necessary that no buyer has to in case of breach of condition, the buyer has to repudiate the contract, because we just have read it that buyer can treat the condition as warranty. it has the option, right? He has option to treat the condition as warranty. When he is treating the condition as warranty, in that case he's not repudiating that contract, neither he is no returning the good. So in that case what he has right only to claim as damages. So in case of breach of condition, the buyer has lot many other option, like one is your repudiation of contract, another is your claiming damages, or he can repudiate as well as claim the damage. Okay. So when he repudiate the contract, obviously he is returning the good. But in breach of warranty, it is rightly said, only damages can be claimed. You cannot no repudiate the contract. And third, very important difference is your whether you can treat warranty as a condition. Whether the buyer has option to treat warranty as a condition. No, correct, Ananya. But can buyer treat condition as a warranty? Yes, Kisan, correct. So he has option to no he the voluntarily he has option to treat condition as warranty. That is specified in your first point. So voluntary waiver, if you can see from the first point, it is that he elect no what he exactly doing. He is waiving the performance of a contract, and second is your elect he is electing to treat as a condition. That's what it says in voluntary waiver. Okay. But in case of compulsory waiver, he's not if the law itself excusing for non-fulfillment. So if the condition has been excused by law, fulfilling that condition has been excused by law, then it is a compulsory waiver. Or if your it is non-severable from the contract, like the example which I have given in case of XYZ wood. Okay, this you have to read it very carefully, because it is going to say you both condition as well as warranty. So here the most of the confusions comes. So please be careful and no have attentive while listening. Okay. So what section 14 says, implied undertaking as to title. In a contract of sale, unless the circumstances of the contract are such as to show a different intention, there is an implied condition on the part of the seller that in the case of sale, he has right to sell the good, and that in the case of an agreement to sell, he will have a right to sell the good at the time when the property is to pass. Please apply yesterday class and tell me what exactly it is saying. It has given you two such scenarios. Okay, one is your sale, another is your agreement to sell. Okay, and it is saying you that there is an implied condition. What means implied means you are the buyer and the seller is not expressly saying what should be the no, representation, or what should be the criteria to be in this contract. This is an implied, it should be there in this. Okay, so one is your in case of sale, he has right to sell. So that means he should have that ownership of the good. Okay, or in the case of an agreement to sell, he will have a right to sell. That means when he is at, when the time will come when he has to sell the good, that time he should have that property in his name. Okay, so it talks about title in good. So this is title in good is your implied condition. It need not required to be said on a okay. Now an implied warranty. Yes,
Ma'am,
yes, Priyanshu.
ma'am means like basically what you mean to say is that when you buy something, the law assumes the seller actually owns it. like, or will when the time comes that nobody will bother you or take it from you after you have bought it, even if that's not written in the contract. That's what you mean to say?
The first line is correct. Second line is we are going to discuss in your clause B. Okay, so when here we are saying implied undertaking as to title, there is two kind of no property in it. One is your general property, another is your special property.
Yes, ma'am.
So okay, so general property is like your ownership is your general property. With the general property you have many other benefits associated with this, which we have already discussed in our yesterday class. So the first point what it is saying about the general property, that in case of and the general property is your implied condition. But when you have mentioned that nobody should bother you, okay, that means you should have a quiet possession of that good. Correct?
Yes, ma'am.
So that is your implied warranty and not implied condition. So if I have given you in our yesterday class, we have mentioned that a person has sold the good which is already placed to somebody else. Now the if that person will not pay that debt amount to whom that good has been placed, then the person who has no special property on that person can take over that good. So you will not have the quiet possession of that good, though you have the ownership.
Yes, ma'am.
Okay. So C point, an implied warranty that the goods shall be free from any charge or encumbrance in favor of any third party, not declared or known to the buyer before or at the time when the contract is made. This is just the same example if we can apply here. So it is saying that it should be free from any charge or encumbrance. And if suppose if it is no having charge or encumbrance, then in that case buyer should have knowledge about it. Correct? And this is your implied warranty, not implied condition. So in that case, suppose if the buyer suppose the seller has done the breach in this. So he has placed that good but he has not informed to the buyer. In that case the buyer has no option to repudiate that contract. He can either sue no he can either ask the seller to pay that charge amount to whomever he has taken loan, or no has put it on a place, or any other encumbrance is there on that. So he can ask him to make the payment, or he can either make the payment by himself and sue for damages. Correct? Okay, sale by description. Where there is a contract for the sale of goods by description, there is an implied condition that the good shall correspond with the description. And if the sale is by sample as well as by description, it is not sufficient that the bulk of the goods corresponds with the sample if the goods do not also correspond with the description. What exactly it is trying to say? The first line it is saying that if the goods no sold by a description, that it should tally with that description. If you are saying that कि 5 mm विथ का आपको एक स्टील प्लेट चाहिए, तो वो 5 mm विथ का ही स्टील प्लेट होना चाहिए. So it should tally with that description. Now in the second part it is saying that अगर सेल जो है वो सैंपल एज वेल एज डिस्क्रिप्शन से हुआ है, तो ये सफिशिएंट नहीं होगा कि बल्क ऑफ द गुड्स जो है वो सिर्फ और सिर्फ सैंपल से कॉरस्पॉन्ड्स हो. And this line, you please let me know what you are understanding.
Ma'am, excuse me, ma'am, which part you were saying to like
So I
to
am
read?
trying to see here. It is this entire part. Okay, if the cell is by sample as well as by description, in that case, what the law is saying?
Ma'am, that the product that you receive must match with the description.
No, see, there is two thing happen here. In case, in this, what is happening, suppose, no, you have, the seller has, you have specified particular description that you want, 5 width of, steel plate. Okay, and the seller has also shown you, certain sample, and the might be, the plate might be of different, no, designs and something like that. Okay, now you have chosen, one, uh, kind of plate which is which is, no, fulfilling the description. And what you have done, out of many sample which has been provided, you have chosen one sample, right? Now, that good which you are going to purchase, that must be, no, having the equivalent to, that must be tallying with that sample as well as description, or it should be not.
Ma'am, it should tally with the description.
Not only with the description, Priyansu, it should tally both. Because you see, in this, what is happening, you have mentioned certain description. What is description? The law is not informed us that what is description, but what our understanding is that certain essential characteristics, like here, when I have mentioned that 5 of, width of steel plate, right? Or if you can say that, any other, characteristic you have specified, or, description might be, no, uh, your Bengal Sandesh. That is what, it has a GI tag, right? So, it is again a description. Now, if I am going to give you, Telangana Rasgulla, that is not going to match with that description, right?
Yes, ma'am. Yes, ma'am.
So this is, so what is description? Some essential characteristic, or some other, no, uh, it might be with regard to origin, or with any
Yes,
other,
ma'am. Any kind
characteristic.
of, yes,
Huh.
any kind of.
So when we are saying that you have mentioned the description, now what is about the sample, when the goods should match with the sample as well as the description. Now you have given, no, might be that steel plate has certain design, so the seller might have 5 of, same, characteristic, but has different design.
Yes,
you
ma'am.
you might have selected one sample.
Yes,
Okay,
yes.
it should match with this. Now what, when the seller is selling the good, it should not only match with the description, it should also match with the sample.
Yes, ma'am. Yes.
This is what it is saying.
So, ma'am, in simple meaning, I can understand that if you buy something based on the description, the law says that the product you receive must match the description. Like example, if you buy a like 100% cotton T-shirt, the T-shirt must actually be 100% cotton and white. If the condition is that the shirt color must be white, and if the sale is by both sample and description, then it is not enough like that the product looks like the sample, it has also to match the description exactly. But
Exactly, this is what,
yes,
the
yes,
correct
ma'am. I
answer
got,
is.
I get it, ma'am.
Yes. So, why this understanding is very much important, that, what in our examination, what happened, certain cases or scenarios has been provided to you, in that you have to apply those understanding. Okay, section, 16, implied condition as to quality or fitness. Okay, subject to the provision of this act and of any other law for the time being in force, there is no implied warranty or condition as to the quality or fitness for any particular purpose of good supplied under a contract of sales. Okay, what the law is saying, no implied warranty or condition as to the quality or fitness. Okay, in the section 16, the heading is saying, marginal heading is saying implied condition as to quality or fitness, but here what the law inside it saying, no implied warranty or condition. Why is it so?
Ma'am, because by automatically there is no condition imposed on it.
Mm-hmm.
Ma'am, I think it's the buyer's. The buyer should cautious about the quality and the fitness of the product of the goods. Sorry.
Yeah, very close. So from this statement, your caveat emptor concepts comes in. Okay, buyer be aware.
Right. Right.
Yes. So there is no as such implied no warranty or condition as to the quality or fitness for any particular purpose of goods supplied under a contract of sale. So if the buyer has certain purpose of goods, and if it is the buyer's duty to fulfill to see that whether that good is going to meet that purpose for which he is buying. So as such there is no implied warranty or condition, but there can be express. If it is specifically mentioned in the terms and contract, that is a different case. But what we are discussing about it, that it is the duty of the buyer to see the quality or fitness, whether it is going to meet his purpose for which he is buying. Okay, this is what the law is saying here. Now, except as follows. However, the law is also giving certain exception. In this, I will just elaborate further. Uh, यू माइट हैव गॉन ना एनी मेला वेला में आप जाते हो तो वहां पे एक ओपन मार्केट होता है, वहां पे आप लोग गुड्स लेते हो, राइट? कोई आपने कोई सामान खरीद लिया अपने आप ही, तो आप क्या कर रहे होते हो, आप वहां पे खुद चूज कर रहे होते हो कि ये पर्टिकुलर चीज जो है आपके पर्पस के लिए है या नहीं, and the seller is not going to tell you or going to say anything to it. If you have picked that by yourself, and you just see that ki, okay, it is going to serve that purpose for which I am buying, then it is you who is responsible for that. Okay, this is what it is trying to say, but there is a certain exception which the law is giving. Number one is your where the buyer expressly or by implication makes known to the seller the particular purpose for which the goods are required, so as to show that the buyer relies on the seller's skill or judgment, and the goods are of description which it is in the course of the seller's business to supply, whether he is the manufacturer or producer or not. There is an implied condition that the goods shall be reasonably fit for such purpose. So what are the criteria law is giving? You have relied upon this seller's skills or judgment. You have stated him either in express word or by implication the particular purpose for which you are buying, and goods are of such a description which is which it is in the course of the seller's business to supply, whether he is the manufacturer or producer or not, that is irrelevant. Then in that case there is an implied condition that goods should be reasonably fit for such purpose. So there is three criteria the law is saying. One is you have made him aware your purpose. Another is you have relied upon the seller's skill or judgment, and that goods which you are going to buy, that is of of such a description which the seller in the ordinary course deal with it. Correct? So if I give you an example, suppose if you went to a pharmacy and you have stated that you are looking for certain medicine which is for because you are suffering from fever, and obviously the seller is having that skill and judgment. Whatever the medicine, you have already stated the purpose for which you are requiring the medicine, and goods are of such description that is in the ordinary course of seller's business. In that case, if he has given instead of fever medicine, if he has given such any medicine which is for dehydration, then in that case what, he will be liable, right? And not the buyer. provided that in the case of a contract for the sale of specified article under its patent or other trade name, there is no implied condition as to fitness for any particular purpose. Okay, so this is your key point. Here we have read that when the implied condition will come up, but here it is saying that the implied condition will not come when the specified article which you have bought is of no having certain patent or have certain trade name. So in the first example, if I say that that pharmacy example, suppose that was an Ayurveda pharmacy which I was saying earlier. But now secondly, if you went to an allopathy pharmacy and you bought you have mentioned paracetamol has patent when he has, not now it has patent, but when the first time he has no found that composition, or it is serving that purpose, that initially it will have that 20 years of patent, right? So when you are buying certain thing which has patent, then it is expressly mentioned, that is an express representation. Or if I can give you one example, like your fridge. uh, so the LG has given one advertisement wherein the door has the cooling quality, right? So when it is the first refrigerator uh, which the LG has no made, and it has patent for 20 year, that cooling quality on door. So that is an express condition again, because on that quality, on that characteristic itself the patent has been taken, and on that characteristic the buyer is buying that good. So there is no implied condition here. Okay. Or other trade name. So there is a goodwill for say there is certain goodwill uh, you might have read about passing of trademark, wherein you would have not registered that trademark, right? But because the people no knowing it for that purpose, it has that is called your passing of trademark. It is not required to be registered because of certain certain checkbox which has fulfilled, like people are knowing that and people are buying for that, and it has lot other things which is you can read it later on. So if because of that trade name people are buying it, that time also it is an express condition, it is not an implied condition. So that's why it is mentioned that there is no implied condition as to fitness for a particular purpose. It has express condition for the particular fitness, because for that reason you have bought, but not the implied condition as to its fitness for any particular purpose. I hope it is clear.
Ma'am, I am clear about this concept, but ma'am, do you think there exist some loopholes in this section?
You tell me what do you think, what loophole it has?
Ma'am, like in the case of a contract for sale of a specified article, there is or other trade name like you specified, there is no implied condition as its fitness or any particular purpose. There is no implied condition. So if a buyer asks for a specific brand item, like for example, he wants to buy a Apple MacBook, the seller is not legally responsible if it doesn't meet the buyer's needs. So I
No, no,
think.
no, no. You are just understanding in a wrong manner. What I have mentioned, that it has not implied condition, but it is an expressed one.
Hmm.
So if he is breaching that, then it is expressly mentioned that you have to fulfill those things. So if the LG
Yes,
door
ma'am.
is not having the cooling quality, that
Yes.
means you can still sue him, but not for the implied condition, but for the express one, because for
Okay.
that reason he has taken the patent, right?
Yes, ma'am. Yes. As stated in the example of paracetamol. Yes, ma'am. I got it.
Yes. So it's what people most of the time can get confused what exactly it is saying, that okay, it is not an implied condition, so I can just know if the seller is just selling something else just by putting certain others other that what the example which you have given, in that case though, if the seller is always free from any kind of liability. No, if it has not an implied but an expressed one, because on that only the patent or the trade name is there. and you have breached that. Okay, second point, where the goods are bought by description from a seller who deals in goods of that description, whether he is the manufacturer or producer or not, there is an implied condition that the goods shall be of merchantable quality. Okay, what is merchantable quality?
Sellable, ma'am.
Yes. So, suppose if you have bought, if I can say that case, you have bought a milk and a milk packet, and it has some kind of no virus in it. That means also it is not sellable. So you went to a milk vendor, and you have given a description that you want an A2 milk, but but it is not of merchantable quality. So merchantable quality or not, that buyer cannot see it, right? Because it is a latent uh, characteristic. Whether that has a virus, certain virus, that even the buyer cannot able to see, right? But a buyer can see what patent defect. So any kind of naked eye defect that a buyer can observe, but any kind of latent defect. See, there is two things. One is your patent defect, latent defect. Patent is, in simply put, if in a layman language, is your naked eye defect. Okay, which is visible upfront, prima facie, that is visible. So for that, the buyer will be responsible. But anything which has no latent defect, like your merchantable quality, like if the milk is having certain virus which is obviously not no consumable, so this is for that, your seller will be responsible, right? So when goods are bought by a description from a seller who deals in good of that description, there is an implied condition that the goods shall be of merchantable quality, provided that if the buyer has examined the goods, there shall be no implied condition as regard defect which such examination ought to have revealed. See, this is what I'm trying to say. Ought to have revealed. So, if I can say that in case of curd, अगर आप और if I say that any other thing जो कि आपको दिख रहा है इसमें एक white layer आ गया है जो कि नहीं आना चाहिए था, राइट? सो आप उसको देख पा रहे हो, तो दैट इज कंप्लीटली विजिबल फ्रॉम योर आईज. सो दैट विच नो थ्रू एन इंस्पेक्शन आप उसको देख पा रहे हो, और उस इंस्पेक्शन के बाद अगर आप उसको परचेज कर रहे हो, देन इन दैट केस सेलर इज नॉट रिस्पॉन्सिबल. लाइक आपने देखा होगा कि आप कोई इलेक्ट्रिकल प्लेस में जाते हो और आपको कोई केटल लेना है जो आपके पानी को गर्म करना होता है, ठीक है? तो क्या करता है सेलर, आप वो एक स्विच में आप पहले उसको देख मतलब वो एक टेस्ट कर ही देता है, पानी डाल के आपको दिखाता है कि वो गर्म हो रहा है या नहीं, राइट? सो दैट इज द एग्जामिनेशन पार्ट. सो वंस आप उसको लेके फिर अपने घर में गए एंड फिर आप उसको यूज कर रहे हो और वो नहीं काम कर रहा है, दैट टाइम you will be responsible. You cannot repudiate that contract. But certain thing which is like the milk example which I have given, that is not visible from the naked eye, right? So such examination, through that examination you are not able to reveal it. So in that case, seller will be responsible. Any question? Okay, third
Ma'am,
point.
ma'am, I have a doubt.
Yes, Priyansh.
Uh, Ma'am, like in the proviso clause, it has been said that if the buyer has completely examined it and he found some defect, then the seller is not responsible. But what if, like for an example, I say I got a phone from like a seller. I got a phone from the shop. I checked it completely. It was working fine, and but after 20 days I found that the screen is getting like it's scrambling, and the speaker is not working properly, and the battery is draining like in 20 minutes. So in that case, can I say that the seller is not responsible for that, or shall I directly claim the warranty as we do generally?
That's what warranty, no? That's you have to see that ki you it's actually depends upon facts and circumstances. Suppose you have that's wherein suppose you have already specified that you want a particular phone which need to have certain battery quality, or which need to be meeting this characteristic which you have just mentioned. So if in that case, if the buyer if the seller has sold you a certain phone which is not meeting this characteristic, in that case you can you can return that phone, and you can claim damages and repudiate that contract. But if it is not specified, and these are there is a warranty provided by the there are many such phone which is of certain qualities which even the buyers are aware about it, and uh, the warranty in that case, it is just a breach of warranty, and you can only claim for damages. You
Okay,
can get
ma'am.
it
Got it.
repaired. Yes.
Yes, ma'am. Ma'am, but again, if I would like to follow up a question, like, then it's not of a merchantable quality. So,
No, no, it is not a merchantable quality. It is not you cannot say like that. So that's the reason why I have mentioned that what is merchantability. So
okay.
it is again, merchantability depends upon each with regard to good every goods. There is different kind of you can mention that merchantability definitions has to be seen like how in every facts and circumstances. So if I say that where the goods are bought by a description from a seller who deals in goods of that description, okay, then suppose if you have bought the phone, but if you have bought an iPhone, so iPhone has already mentioned the particular characteristic it possesses, so it should have that characteristic. And if that iPhone is not having that no whatever the representation iPhone seller has given you, if that is not meeting, then it is breaching the merchantability quality. But suppose if you have bought a phone which is not it is just from any random which has no such uh, not giving guarantee upon those characteristics,
Yes,
right?
ma'am. I got. Yes, ma'am.
Yes. So in that case it is again it, the same threshold will not apply. So how the threshold depends upon each facts and circumstances, depends upon goods, and depends upon express the terms and conditions which you have no mentioned in that contract. I hope it is clear.
Yes, ma'am.
Okay. So we are in third point. Yeah. An implied warranty or condition as to quality or fitness for a particular purpose may be annexed by the uses of trade. Can anybody try it? What exactly it is trying to say? It is saying that by uses of trade आपका अनेक्स हो रहा है कोई एक implied warranty or condition. Can anybody think of any such example? Try. आप ऐसा कौन सा ना मतलब what do you mean by uses of trade? First of all, try to answer that. So
Ma'am, the common practice that we like do in a day-to-day life, like whatever kind of like in cooking, if someone is cooking day-to-day regularly, serving people, so we can say that is a usage of trade or something like that.
सो यूसेस ऑफ ट्रेड मतलब वो आपका ट्रेड के ही मतलब आप मतलब कॉमर्शियल वर्ल्ड में जो आपका जनरल बैलेंस में देखा जाता है कि ये चीजें ऐसी ही होनी चाहिए। जैसे मान लीजिए कि आप स्मॉल साइज का कोई गुड्स कोई क्लोथ खरीद रहे हैं, रेडीमेड गारमेंट,
Yes.
तो वो आप यूसेज ऑफ ट्रेड ही है ना, कि आपका वो एक स्मॉल साइज, एक पर्टिकुलर साइज मीट करता है क्राइटेरिया, राइट?
Yes.
और
Yeah.
लाइस,
Yes.
हाँ, सो दैट इज अ यूसेज ऑफ ट्रेड इटसेल्फ। एनी
Yes.
वेंडर, आप किसी के पास से भी आप खरीद लेते हो, और दे हैव नॉट स्पेसिफाइड कि दे हैव, मतलब अगर उन्होंने कुछ और साइज आपका हिप और इसका अगर उन्होंने मेजरमेंट नहीं दिया है, तो जनरल बैलेंस में जो स्मॉल साइज का मीनिंग होता है वही आप समझोगे यूसेज ऑफ ट्रेड के अंदर में,
Yes,
यही,
ma'am.
दिस इज व्हाट इट इज। सो आप अगर रेडीमेड गारमेंट स्टोर से आप अगर स्मॉल साइज परचेज कर रहे हो, तो इवन आपका वो स्मॉल साइज, अगर उन्होंने अपना साइज का मेजरमेंट नहीं मेंशन किया है, तो आप किसी भी और जितने भी रेडीमेड गारमेंट है उस सबके स्मॉल साइजेस का नॉर्मली यूसेज ऑफ ट्रेड के हिसाब से वही एक पैरामीटर साइज का मीट करता है। That's
Yes, ma'am.
what it is trying. And if it is breaching that, that means again that is an implied warranty or condition. Okay.
Yes, ma'am. I got it.
Yeah. Now the fourth point is your an express warranty or condition does not negative a warranty or condition implied by this act unless inconsistent therewith. Okay. So what it is trying to say that कि अगर express warranty or condition है, सो दिस इज व्हाट ट्राइंग टू से दैट कि अगर सपोज आपके आपके कुछ चीजें आपके इम्प्लाइड है, लाइक इम्प्लाइड वारंटी एंड इम्प्लाइड कंडीशन इज देयर, दैट डजंट मीन कि आप उसको एक्सप्रेस में भी नहीं कर सकते हैं। यू माइट हैव सीन मेनी अ टाइम दैट नो समथिंग व्हिच इज वेरी मच इम्प्लाइड, पीपल आर इवन मेंशनिंग दैट in their warranty card, that it has this much of lasting period, or it is no the bulb lightens, like this obviously the bulb will light, it has the no condition, it is the essential condition of it कि bulb जो है वो lightning के लिए ही है। So but that even people sometime mention in their contract, right? So that means that it will not negate the implied warranty or condition if something which you are mentioning in express term, but if something which you are mentioning express term which is not implied, like suppose if it is cancelling the implied one, so say suppose that there is an implied warranty that it should have a quiet position, but you can by an express word mention that it will not have an quiet position. You will be sharing the same with my relative, like in case of covenant running with the land, right? That kind of condition precedent or condition subsequent can be given, right? So by express you can if something by an express term you are no canceling the implied term, that can be possible, so inconsistency might be possible. Is it clear? See, I give you an example by just we have read here. uh, you can see an implied warranty that the goods shall be free from any charge or encumbrance in favor of any third party not declared or known to the buyer. So through express term, in general what is happening, it should be free from encumbrance. That is what implied warranty in the second clause b we have read it. Okay. Or quiet possession is there. So but when there is an encumbrance, so that means you will not going to have a quiet possession. If you are not paying the place amount, the to whom you have placed, he can take over that good from you, right? So by specifying in the contract, you can no have you can waive this right. So through express terms you can even no have an inconsistent to what is provided by implied what is implied by the law. Is it clear? Any question? Okay. Now section 17, sale by sample. A contract of sale is a contract for sale by sample where there is a term in the contract express or implied to that effect. In the case of a contract for sale by sample, there is an implied condition that the bulk shall correspond with the sample in quality. Okay, so you have no You have given you have shown certain sample which is of certain quality. Say suppose if you went to buy a sunflower oil, and the sample which has been shown to you is of sunflower oil only. So that means the bulk which later on to be provided to you should correspond with that sample in quality, right? That means that must be sunflower oil only, that the buyer shall have a reasonable opportunity of comparing the bulk with the sample. So they should give you a that reasonable opportunity to inspect that the samples that bulk should match with the sample, that the goods shall be free from any defect rendering them unmerchantable which would not be apparent on reasonable examination of the sample. This is covering your latent defect. Okay. So certain thing which is very latent, like suppose if the sunflower is having certain quantity, the bulk which has been given to you prima facie looks like a sample, like the same sunflower oil, but it has no some quantity of hemp oil or coconut oil which you cannot able to see from your naked eye, right? So it prima facie match with the sample, but it is not matching as such. So this is a latent defect which you cannot able to see from your naked eye. So that the goods shall be free from any defect. So it is obviously having a defect which is making it unmerchantable because you went to buy a sunflower oil, not something which have no coconut oil or any other oil, and which would not be apparent on reasonable examination of the sample. Obviously you will not able to see from your naked eye.
Yes, ma'am.
Okay, I think I have completed condition, warranty, and your uh, this. Let me. I have bucketed it for your purpose. Just a minute. I'll show you. Okay, so we have completed difference when condition treated as warranty, implied condition. So if you have seen while going through a barrett, it has not given you a point wise that okay, okay, these are the implied conditions, these are the implied warranties. So this I have no for uh, simplifying, I have put it into a point that the law says that these are the points which are implied conditions. Okay, condition as to title, condition as to description, that it should match with the description what you have given. Okay, sale by sample, wherein if you have only suppose, see, there might be a situation wherein you have given a no description. So it is again, then it is a condition as to description, uh, because that goods must meet that description. But suppose the seller has only shown you certain sample and you have not given any description. By seeing that sample you have given an order, placed an order. That means it is again an essential to the contract. Okay, because you have bought it by seeing that sample. So this is a your condition, implied condition, that it should meet the bulk should meet the sample. Then fourth is your sale by sample as well as by description. So this is again your condition, wherein your bulk should match both the sample as well as your description. Fifth is your condition as to wholesomeness and condition as to merchantability. See, wholesomeness is usually it is very difficult to know segregate the difference between merchantability and wholesomeness. So usually the wholesomeness apply to any eatables or any provisions which we buy from grocery shops. Okay, and merchantability is usually with regard to any other goods. Like suppose if you went to no showroom to buy a thermos to keep the water hot, right? So uh, if that is not if that thermos is not keeping the water hot, that means it has no merchantability, right? And the wholesomeness, the example which I have given you with regard to the milk, that it has certain virus, so then it is breaching that wholesomeness. Okay, implied warranties. So these are four warranties which the law says: warranty as to undisturbed possession, warranty as to non-existence of encumbrance, disclosure of dangerous nature of good. This is something is that buyers should be aware about the dangerous nature of that good. Suppose uh, if there is a if the water is not no, kept in a certain way, then it is there is a risk that this is going to blast. So if certain characteristic with is there with that good, then it is the duty of the seller to inform that to the buyer. Okay. Warranty as to quality or fitness by usage of trade. That ready-made good ready-made no, garments we have discussed with regard to this. Caveat emptor. Okay, so we have we in a general parlance, it is not the responsibility of the seller to make the buyer aware about the fitness and the quality of good. But if so, it is if the good is defective, then seller has no responsibility. Seller is responsible when, uh, in general parlance, it is the buyer who has to apply his own skill or judgment. But if the seller is that exceptions we have already discussed in our while discussing the act. Okay, so what are the exceptions which has been provided? Buyer makes make known the particular purpose, good purchased under its patent name or brand name, for merchantable quality of goods, sale by description and sample, in case of condition implied by custom. And the last point is your consent of the buyer in a contract or sale. Contract of sale is obtained by the seller by fraud. So this is the another point, wherein suppose the buyer has been induced by certain description, and on that description, suppose the seller has sold that good. So and the seller has obtained such consent for purchase only no, by applying fraud. Say suppose seller has sold a horse which is vicious, and seller has given certain kind of medication to the buyer, to that horse. So at the time of showing that horse to the buyer, the horse was completely behaving normally, because he's that horse is under certain medication. But after the purchase, the real no that the buyer is able to know that the horse is vicious. In that case, that consent to buy that horse is obtained through fraud. So in that case, seller will be responsible. He will not take the benefit of cave attempter. Okay. Any queries? We have completed our today's agenda. Any queries?
No, ma'am. Ma'am, can we get this PPT for like I want to recap everything. So can I get this exactly this part that what we have read today? So can I get that?
As such, though, I have just everything is there in the act itself. But what I did, I just bucketed it for simplifying for you. I'll just try it how it has to be provided to you all. Uh,
Yes, ma'am. Ma'am. Just for a daily recap, like if I can see it for a daily, I can recap everything, like for short recap. That's why I
yeah,
asked.
yeah, I understand. I understand. I'll just talk to the platform ab initio, and we'll see how it has to be provided. Okay.
Thank you,
And
ma'am.
yeah, thank you. Anybody else? Any queries? See, one very important is in the no that key, apart from, if you have seen that what I did, I have just noted down all the whatever we have studied in the barracks. I have just noted it down in the point form, right? So this is a tool which is very helpful. So apart from understanding the law, you should also understand how to make notes. So if just what I did, see, I have no I have noted down what are the implied warranties when because in the section is also saying the implied condition and implied warranties together, right? So I have just segregated. So if you will make your notes in a no key points, this then it will be helpful for you to later on revise it. So
Yes, ma'am.
So it is not generally for only for the contract act, for any other law. So I want you to learn those skill as well.
Yes,
While
ma'am. I usually practice that thing. I make like I have my sticky notes. So whatever I think that it should be in a one-liner, like from like starting of an FIR to up to till judgment. I've made some pointers, like in giving arrow marks like this after that, this after that, this. So it will be easier. I make such kind of things like to remember.
okay, what I used to do that, पहले तो आप सबसे पहले whatever you are studying ना, just read it like a story book. So you just need to understand it, the soul of it. So when you have the understanding of what exactly the law want to say, like why we are studying, that's why in many of my sessions you have seen I have asked some random questions which might not be very uh, might not be the examiner might not be asking you, but it will give you no understanding that we should think that what do you mean by stipulation. I don't think the examiner is going to ask you, but when you have an understanding what the stipulation is, what do you mean by stipulation, what do you mean by merchantability, what do you mean by wholesomeness, so when you have an understanding in a general as in a story ways, then you will easily understand the law, and then you need not require to remember. And when you whatever you are understanding, when you have a clarity of the understanding, those points which you think that it is confusing, that only you highlight it, so it will no lessen your burden. You will otherwise the law is itself very heavy to read. So those which mostly you are forgetting, or those which you are making mistake in understanding, those you highlight it as in sticky notes. What this is what I used to do, and the rest of the part I don't do, because I understood it. I just highlight the key points, like the way it's an
Yes,
implied
ma'am.
warranties.
Yes,
So these are the
exactly.
key points. Now I
Yes.
understand this point what it means, so you need not required to note it down everything or highlight it
Yes, ma'am.
everything.
Yes, ma'am. Like, what is exactly confusing you? You can just clarify that in that note.
Yes, yes, yes. And those which you are actually forgetting always, that okay, this is this sometime what one of the points you might miss while remembering. So obviously that time you just see two or three times that okay, every time I miss this point, then that means this need to be highlighted and I have to remember it. And the rest of the no points are already flowing in your blood. So it is just like a story. You need not require to no remember your friend name, or many of the things which is happening in your life, because it is there in your habitual life. Similarly, for the law also, if you do the same thing, that you just understand it as a story, and then even in midnight, if somebody is going to ask you, okay, what is this, like what is merchantability or what is wholesomeness, you can easily say it na. So then you can have an understanding when it is in implied condition, when it is, what do you mean by condition, what do you mean by understand warranty. You need not required to again remember mug it up. You just need to no vomit it what you have an understanding. So try
Yes,
to
ma'am.
do that way.
Yes, ma'am.
That
Yes,
would be
ma'am.
much helpful. And try to make the key pointers like this, the way I have just mentioned in the ppt,
Sure,
so
ma'am.
that it will be easy. Okay, thank you all. Thank you.
Thank you, ma'am.
Yeah. Yes, yes, anybody is asking something? Okay. Okay, good night. See you tomorrow.
Yes, ma'am. Have a nice day, ma'am. Good night,
Thank
ma'am.
you.